Modern real estate practice, page 143. Email/texting. Email and texting, its cell phone equivalent, have made communication between real estate professionals and consumers more efficient. Email is an excellent opportunity for the ongoing marketing of a business. Contact information should be kept up to date and appear in every message. State licensing regulations may specify the information that should be provided in every client or customer communication, including electronic communications. Laws against unwanted email messages are discussed later in the section on prohibited communications. In communicating with clients or consumers via email, the best practice is to see the subject line in a useful and helpful manner. Avoid spelling errors. Respond promptly to all email messages. Be specific and brief, and pay attention to the size of any file attachments. Never send unsolicited email messages. The same type of recommendations apply to text messages, which are rapidly overtaking email as the preferred method of client contact. Be clear while being concise, making sure that the subject of the message isn't lost, and avoid too many text message acronyms. State law may require that all communications by real estate professionals include their name, address, license number, and for a sales associate, the name of the employing broker. Social media. The latest methods of communicating via the internet include Facebook, www.facebook.com, which allows users to post a page of information and receive and send messages from identified friends. The popularity of a Facebook page or posting can be measured by the number of users who indicate by clicking on an icon that they like it. A real estate professional can establish a presence on Facebook, but should always be mindful that information available to the public imposes a level of restraint on comments and photos posted to avoid embarrassment or even potential liability. Twitter. www.twitter.com allows users to post short messages called tweets of no more than 140 characters that can be read by others who follow that user. Tweets can be a useful and entertaining way of gathering comments from a number of people on a variety of issues, from politics to entertainment. LinkedIn. www.linkedin.com emphasizes business networking by allowing users to post brief resumes and to join groups of those who share similar interests. When users update their information, members of their group receive those updates. Users can also post announcements or messages to members of their groups, allowing others to post comments or responses in return. Internet advertising. State laws vary regarding internet advertising. It is important for you to check your own state's law before engaging in advertising and other marketing activities on the internet. In addition to NAR's Internet Data Exchange Policy, internet advertising laws and regulations frequently include the following stipulations. All electronic communication by a real estate professional must include the professional's name, office address, and broker affiliation. Real estate professionals must disclose their license status on each page of a website that contains an advertisement. The listing of only a sales associate's name without the sponsoring broker's name in an advertisement is prohibited. An advertisement must be a true, current representation of the information it contains and not be misleading. Social media, www.facebook.com, www.twitter.com, www.linkedin.com. Page 144, electronic contracting. The legal requirements for a contract will be discussed later, but it is worth noting here that technology and the internet have significantly changed the way in which real estate transactions are performed. Electronic contracting is a growing part of real estate practice because it quickly and efficiently integrates information in a real estate transaction between clients, lenders, and title and closing agents. The transactions are conducted through email or fax and can save both time and money. Two federal acts governing electronic contracting: the Uniform Electronic Transactions Act, UETA, and the Electronic Signatures in Global and National Consumer Act, e-Sign. The Uniform Electronic Transaction Act, UETA, was created by the National Conference of Commissioners on Uniform State Laws, www.uniformlaws.org. At present, UETA has been adopted by all but 3 states: Illinois, New York, and Washington. The law sets forth basic rules for entertaining and enforceable contract using electronic means. The primary purpose of UETA is to remove barriers in electronic commerce that would otherwise prevent enforceability of contracts. UETA validates and effectuates electronic records and signatures in a procedural manner and is intended to complement a state's digital signature statute, but it does not in any way require parties to use electronic means. UETA's 4 key provisions are the following: a contract cannot be denied its legal effect just because an electronic record was used. A record or signature cannot be denied its legal effect just because it is in an electronic format. If a state's law requires a signature on a contract, an electronic signature is sufficient. If a state's law requires a written record, an electronic record is sufficient. An electronic signature is in Global and National Commerce Act, e-Sign, was passed by Congress in 2000. E-Sign functions as the electronic transactions law in states that have not enacted UETA, and some sections of e-Sign apply to states that have enacted UETA. The purpose of e-Sign is to make contracts, including signatures and records legally enforceable, regardless of the minimum in which they are created. For example, contracts formed using email or transmitted electronically rather than by paper have the same legal significance as those formed on paper. In practice, when entering into a residential sales agreement, it is important for the parties to feel comfortable with and clearly communicate the method chosen for transacting the agreement, whether by paper and ink or by email. Prohibited communications. Businesses must comply with a variety of prohibitions intended to protect consumers from the intrusions of unwanted communications. In 2003, federal do not call legislation was signed into law, and the Do Not Call Improvement Act of 2007 further strengthened the protections available to consumers. Real estate professionals must comply with the provisions of the National Do Not Call Registry, which is managed by the Federal Trade. www.uniformlaws.org. Page 145. Commissions. FTC. The registry is a list of telephone numbers from consumers who have indicated their preference to limit the telemarketing calls they receive. The registry applies to any plan, program, or campaign to sell goods or services through interstate phone calls. The registry does not limit calls by political organizations, charities, collection agencies, or telephone surveyors. The law does not apply to a for-profit telemarketer, even if the telemarketer is working for a nonprofit organization. Information for consumers and businesses can be found at www.donotcall.gov. Telemarketers and sellers are required to search the registry at least once every 31 days and drop registered consumer phone numbers from their call lists. Normal business relationships are still possible. Real estate professionals may call consumers with whom they have an established business relationship for up to 18 months after the consumer's last purchase, delivery, or payment, even if the consumer is listed on the National Do Not Call Registry. Also, a real estate professional may call a consumer for up to 3 months after the consumer makes an inquiry or submits an application. Note that if a consumer asks a company not to call, despite the presence of an established business relationship, the company must abide by the consumer's request, which stays in effect permanently. Even though the federal legislation applies to interstate telephone calls, most states also have do not call rules and regulations that apply to in-state calls. It is important to keep up to date with state laws regarding do not call policies, as well as the national law. Similar federal state laws apply to marketing and business communications by fax and email. The Telephone Consumer Protection Act, TCPA, Junk Fax Prevention Act, and rules of the Federal Communications Commission, FCC, prohibit most unsolicited fax advertisements. There is an exemption for faxes sent as part of an established business relationship. More information can be found at www.fcc.gov/guides/fax-advertising. Junk emails, spam, are prohibited by the federal controlling the assault of non-solicited Pornography and Marketing Act of 2003, known as the CAN-SPAM Act. An important feature of this law, which applies to commercial electronic mail messages is that email solicitations must include a means by which the recipient can unsubscribe from future messages. Compliance guide for businesses is available at www.business.ftc.gov/documents. Bus 61-scan-spam-act-compliance-guide-business. The most recent restrictions on the use of the internet, including mobile apps and ad networks, went into effect on July 1st, 2013 as part of the ongoing Children's Online Privacy Protection Act, COPPA. COPPA requires the posting of a privacy policy and limits the personal information that can be collected from children younger than 13, even if the website or app is directed toward a general audience. Details of the law can be obtained at www.business.ftc.gov/privacy-and-security/children's-privacy. www.donotcall.gov. www.fcc.gov/guides/facts-advertising. www.business.ftc.gov/documents/bus 61-scan-spam-act-compliance-guide-business. www.biz.business.ftc.gov/privacy-and-security/children's-privacy.